We've all been patiently waiting for some kind of justice to be done in the various election lawsuit cases where attorneys like Sidney Powell and Lin Wood brought these baseless, unmeritorious, frivolous election lawsuits and then didn't seem to have any ability to prove anything. Normally when you're an attorney, you are an officer of the court and you have to follow some rules of the court, rules of evidence, rules of procedure. And one of those rules, Rule 11, says that you are supposed to have a basis for your various claims. If you're a plaintiff and you bring a lawsuit, you have to have done your due diligence, done your basic investigation, and have a basis for filing a complaint. If you're a defendant, you should have a basis for defending yourself. If you're not innocent, you really shouldn't be pleading innocence and then later on revealing that you're not innocent. Although there's some leeway there, and I see a ton of defendants and plaintiffs getting away with walking the line there. But here in King v. Witmer, one of the Kraken lawsuits, as it's being called, the plaintiffs did a same kind of job as we've come to expect from these baseless election lawsuits. They filed it November 25th and pursued it until January sometime, racking up close to 100 docket entries, maybe even over 100 docket entries before we even get to the notice of voluntary dismissal on January 14th. And I had previously talked about this. There were a bunch of motions for sanctions under Rule 11, under the statute for shifting fees from frivolous lawsuits, and under the court's inherent powers. There were several entries here where the parties asked the court to sanction, or in this case, even disbar the attorneys for having brought such a baseless lawsuit that casts the elections into doubt while doing nothing to actually try and make their case. Well, the court ordered all of the attorneys who had filed that, everybody whose name appeared on that, which was several attorneys, I think it's close to a dozen attorneys, ordered them all to appear in person, but virtually. They didn't have to necessarily show up to court, but they couldn't send an attorney on their behalf. On June 8th, the court filed this notice of hearing by video conference on the motion for sanctions under 28 U.S.C. 1929. Here is the fee shifting section of the law. Then a motion for sanctions, disciplinary action, disbarment referral, and the judge set that for July 6th, but then the motion was adjourned to July 12th. The court adjourned the motion to 7/13, but something that came out of that was this defendant Robert Davis motion for order to show cause why attorney Lin Wood should not be held in criminal contempt for violating local rule 83.32 D3 and E2. There's a lot to unpack there, but real quick, an order to show cause is a way that you ask the court to require somebody else to do something. The defendant makes the accusation that Lin Wood should be held in criminal contempt and asks the court to order the defendant to respond to that accusation. So show cause why you should not be held in contempt. On July 12th, the court held an extensive 6-hour-long hearing on defendants' respective motions for sanctions against the plaintiffs and counsel. During the 6-hour hearing, plaintiffs' counsel Lin Wood was repeatedly disrespectful to the court and was defiant to the court's directives given during the hearing. Surprising, Mr. Wood's total disrespect of the court's orders and directives continued after the conclusion of yesterday's hearing. Within hours of the close of those proceedings, Lin Wood posted a video snippet on his more than 840,000 follower Telegram account featuring Sidney Powell's closing monologue. There's still a prohibition about taking photographs or video recordings in connection with any judicial proceeding. Mr. Wood's rebroadcast of a portion of the court's July 12, 2021 hearing is in direct violation of Local Rule 83.32 for the Eastern District of Michigan, which says taking photographs or recordings is prohibited, and the recording or broadcasting of judicial proceedings by radio or television or other means is prohibited. Mr. Wood's blatant disregard for the local rules of the Eastern District of Michigan and his continued blatant disrespect for this court shall not go unpunished. Local Rule 83.32 provides various punishments and sanctions the court may impose, which includes disbarment and a finding of criminal contempt. Local rules provide in part that a violation of the rule may be punished by criminal contempt of court. Mr. Robert Davis believes that Mr. Wood's actions of deliberately defying the local rules of this district warrants criminal contempt proceedings, wherefore order him to show cause why he should not be held in contempt. So the judge does just that. In the meantime, July 14th, counsel for Plaintiffs' Counsel filed an emergency motion asking the court to release the video of the July 12th hearing in this matter. I guess that would moot the criminal contempt if they released the video. Counsel argues that throughout our history, the open courtroom has been a fundamental feature of the American judicial system. The court, in fact, threw the virtual doors to the July 12th proceeding wide open, far wider than could have been accommodated had the hearing been conducted in person. As counsel notes, more than 13,000 people watched live, viewing the proceedings just as they were conducted. As to counsel's suggestion, this is the court speaking now, as to counsel's suggestion that the video is needed to prepare a supplemental brief, attorneys routinely prepare such briefs following a hearing without video or audio recordings of the proceedings, and often without a transcript. The emergency motion is denied. And then the court addresses the order to show cause. Before the court is a motion for order to show cause why attorney Lin Wood should not be held in criminal contempt for violating the local rules against rebroadcasting. On the morning of July 12th, the court held a virtual hearing regarding 3 pending motions for sanctions. Within hours of those proceedings, Lin Wood posted a video snippet to his 840,000 follower social media account. Eastern District of Michigan Local Rule 8332 prohibits the broadcasting of the judicial proceedings by radio or television or other means. The movement notes the violators may be held in criminal contempt of court and discipline. So we have criminal contempt of court and discipline, and requests the court consider the criminal contempt. The court declines, but will consider discipline. Accordingly, it is ordered that the motion for order to show cause is granted in part and denied in part. Lin Wood shall show cause in writing by July 22nd why he should not be disciplined in accordance with local rules for broadcasting the proceeding on social media in violation. That is Linda V. Parker, U.S. District Judge for the Eastern District of Michigan. So it's happening a little bit. There is a little bit of justice in the world. The court is requiring Lin Wood to explain himself, and if he can't sufficiently explain himself, or if he simply is directly in violation of the rules with no good reason available, then he's probably going to get disciplined. I don't know what that discipline will be. It can be anything from a fine to a referral to a disciplinary committee. Criminal contempt is off the table, so he's not going to jail, and he's not being fined such a high amount of money that it acts as a punishment. Instead, it should be limited to a deterrence function. So I'm guessing it will be a fine of $1,000, something like that. Probably less money than he made off of 840,000 followers, although I don't know how he's monetizing his social media. I do not follow him or even really care to investigate any of that. But that is happening. Meanwhile, there is a transcript of that 6-hour hearing that I kind of wish I had watched, but I didn't, so that's my bad for not being available on Monday to do that for 6 hours. But maybe what I can do is find the transcript or pay for the transcript. Transcripts are expensive, so I expect a 6-hour hearing will probably be $1,000 transcript, or maybe a $600 transcript. So maybe we can somehow all go in together for that transcript. I don't know. If I figure out something, I'll post it, but I'll first have to find out what the court reporter says about the cost of the transcript. Anyway, let me know what you think of that in the comments below. Lin Wood will likely be getting disciplined, and if he doesn't get disciplined, then he should be. I think, in my opinion, he should be disciplined for violating the court's rules. It's not so much that he made some kind of accidental violation of the court rules. He would know that he's not allowed to rebroadcast, and if he did it anyway, there has to be something to stop people from rebroadcasting court hearings. It's like that that bad apple that spoils the bunch, or maybe it's the one bad actor that ruins it for everybody. These remote viewing of these court hearings has been very helpful. It's entertaining, it's educational, and it's firsthand. You get to see the court hearing firsthand without having to go to the courthouse dressed in appropriate clothing, go through security. Sometimes you're not allowed to have your phone, sit there forever. Instead, you can just log on at the appointed time. And I have a feeling that there's going to be enough people who are rebroadcasting or recording or something that we either have to change the law to allow rebroadcasting and recording, or I have a feeling that courts are just going to decline to put their hearings online, which is going to be a loss for access to justice and the transparency of the legal system. But let me know what you think of the whole thing in the comments below. I will have further updates. I'll make this a playlist about King v. Witmer and the sanctions, and we'll follow up with what the court has to say when they make their order, and then eventually I will do a highlight of the 6 hours of transcript once I can get a hold of it. Kahedron just sent the transcript to us. What? Does it matter that the Federal District Court streamed it directly to YouTube? No, it doesn't matter. The court does not allow you to rebroadcast the proceedings. If there could be a copyright fair use argument to be made, but I'm not sure that fair use overcomes orders of the court. It's a real good question. I would like to see court hearings be able to be recorded and rebroadcast. It's kind of like in football or any other sport where you've got cameras everywhere, but refs still have to make live calls without reference to the video. If you just used the video, which would be the best evidence of what happened, then you don't have to rely on whether the ref made a good call or not. They make a call, they stop the play, they review the tape, the recording, and decide whether that was a good call or not, and uphold the call or not. So Katrina, yeah, it's not a copyright claim. A court does not have copyright on videos produced by the government. There is everything produced by the federal government is public domain. It's possible for the federal government to hire someone who records it, and they might own a copyright. Like if the transcriptionist makes the video, maybe that's somehow the copyright of the transcriptionist. But if the court is doing it using the court's technology and the court's system, that's not copyrighted. Like the judge said, there's 13,000 people watching, and players like Lin Wood, they play to the audience sometimes, and you're more likely to play to the audience if you think that your court proceeding is a live stream on YouTube. Transcript. Let's definitely look at this. This is 334 pages long. That would have been an expensive document. That would have been $1,000 document. So apparently this is the transcript in the Dominion voting case. This is the King v. Witmer 7/12 transcript. So whoever posted this, which is defendant Gretchen Witmer, thanks, because this is a 334 page document, and it's probably going to be $1,000 for this transcript, maybe a little bit more. And we're not going to be able to go over that in this video, but I did want to let you know that I do have it. So there's discussion of drafting the amended complaint, court's authority to issue the relief, timing of the filing, mootness, various affidavits, expert witnesses, other affidavits, closing remarks by Campbell, Buchanan, Wood, Gurewitz, Patterson, Fink, Meingast, and Powell. I know the Powell statement was the thing that Lin Wood had reposted. So let's see what she has to say. So Sidney Powell appears to fall on her sword. I would like to speak to all of these issues. We're not waiving anything. We object to virtually everything Mr. Fink has said. I have practiced law for 43 years and never witnessed a proceeding like this, including representing attorneys in sanctioned proceedings themselves. I take full responsibility myself for the pleadings in this case. Newman, Wood, Johnson, and local counsel had no role whatsoever in the drafting and content of these complaints, but they loved to be the face of the effort, didn't they? It was my responsibility and Mr. Kleinhendler's, not theirs. This is not the kind of proceeding in which the affidavits can be challenged. They weren't even required to be attached to the complaint. We attached 960 pages of affidavits to reflect how seriously we took the matter, how concerned we were about the constitutional issues. We had a legal obligation to the country and to the electors to raise these issues. It is the duty of the lawyers and the highest tradition of the practice of law to raise difficult and even unpopular issues. The fact that there may have been even adverse precedent against us does not change that fact. Yeah, it does. When you have precedent, when you have adverse precedent, you're allowed to argue against it, but you have to argue for a reasonable extension of the law, not a frivolous one. Not one that just supports your narrative but has no basis. However, that's what the sanctions hearing is about, is presenting the evidence that you did meet the Rule 11 standard for a reasonable extension of the law or a meritorious pleading. They claim to practice with the highest standards, want to prove their case. They did. They had the chance to prove their case, and they didn't. They voluntarily dismissed it. No, it says no court has given us the opportunity, but then I'm staring at a notice of voluntary dismissal, notice of voluntary dismissal, notice of voluntary dismissal, voluntary dismissal, voluntary dismissal, voluntary dismissal. This was not a court dismissing the case. This was the plaintiffs dismissing their own case. So where did the court not give them the opportunity? She continues to stretch the truth, even here in her own sanctions hearing. She accuses the opposition of abusing the process for political gamesmanship and their political purposes. Yowza. It is at the same time unbelievable as I have come to understand that these are the times that we live in. Anyway, that's the update with that for right now. I will be back to you with the court's decision and selections from this transcript when I'm able to get through 334 pages, hopefully in a week or two. Anyway, let me know what you think in the comments below. And that's today's video. Special thanks to our top supporters in July: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn Abel, ShadowTycho, RDHDragon, Earthbound Star, and PureMagma. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye. up here? I can't tell if you're up here or not. Are you coming up here? What?
I'm trying to make dinner.
You can't open the milk. Oh, your cat. Do you want your cat?
She wants to be here. I haven't seen her.
Hello, Chonk. Yes,
Hey,
Kaylee needed a milk container open because her wrist is still recovering.
Hey, I finally used my channel points.
Channel points?
Yeah, if you watch, you get channel points, and you can get a highlighted message.
Oh, okay, you got a highlighted message. Yes, I was wondering what was going on there.